Thanks very much, Don. So today's presentation is prison penalties for serious domestic and non-domestic assault, conducted by myself and Suzanne Poynton. Domestic violence is a serious crime that affects a large segment of the population. DV-related assaults have increased from 26,000 to 30,000 per annum over the past 5 years. By contrast, non-DV assaults have had a 5.6% decline. Since March 2008, New South Wales courts have been directed to record an offence as domestic violence, DV, if it is satisfied that it occurred within a domestic relationship. It is worth noting that the Crimes Act defines domestic relationships broadly, such as married or de facto relationships, either current or past, intimate personal relationships, having lived in the same household or residential facility, or being a relative or other extended family member. There has been a lack of research on sentencing practices for DV matters in Australia. Historically, this was because it was difficult to reliably distinguish between DV and non-DV offences of the same type using administrative court data. That New South Wales courts now have specific DV codes for relevant offences has now made this comparison possible. Prior research has been conducted by Bond and Jeffries using New South Wales data, and they found that non-domestic offences received harsher punishment compared with domestic offences. Specifically, they found that fewer DV offence finalisations resulted in imprisonment compared with non-DV offences, and also that those DV offences that did result in imprisonment received shorter average prison terms. Using the same data, Jeffries and Bond also found that the effect of DV status on sentence severity varies by Indigenous status. For non-Indigenous defendants, DV offences received lower imprisonment rates and shorter prison sentence length. For Indigenous defendants, there was no difference between DV and non-DV offences in terms of penalty severity, as measured by imprisonment. However, this research included a large range of offence types such as common assaults, serious assaults, robbery, intimidation, which had varying penalties. And these diverse offence types also had a range of statutory maximum prison penalties. So one concern we had is that what we'd like to do when comparing DV and non-DV offences is be comparing like with like in terms of the type of offence. So the aim of the current investigation is to compare prison penalties between non-DV and DV offenders for serious assault offences only. We have three research questions. Firstly, are adult offenders found guilty of serious non-DV assault more likely to be imprisoned than serious DV assault offenders? Secondly, do offenders sentenced to prison for a non-DV serious assault receive longer prison terms compared with serious DV assault offenders? And thirdly, does the likelihood or length of prison sentences for non-DV and DV offenders vary by the Indigenous status of an offender? So the data sources we used were from the New South Wales reoffending database, and as I said before, we're looking specifically at serious assault resulting in injury. And we were looking at all of these matters finalised in New South Wales local courts over the period 2009 to 2014, and these were for adult offenders who were found guilty. And what we did is that we also used, with this data, we used random selection for the small number of defendants with 2 or more finalisations, just to select one of their appearances. And this resulted in 23,140 serious assault offenders. And in terms of the principal penalty, we also looked at, this was imprisonment, and we found that the number of these offenders who received imprisonment was 3,596, and what we measured was the sentence length as defined by the total term. So the analyses, I'll just be brief with this, is that we compared the percentage of DV and non-DV offenders who received an imprisonment penalty. We also compared DV and non-DV offenders who were sentenced to prison in terms of the mean length of their prison sentence. And we also controlled for important covariates which may predict imprisonment. And these include things like the number of concurrent offences, prior offending, socio-demographics, and we also used statistical methods which took account of the local court in which the offendant's matter was finalised. And the other thing that we did in terms of the third research question was to assess whether the effect of DV status on penalty severity varies by Indigenous status. So on to the first question, the likelihood of imprisonment. In terms of DV status and imprisonment, amongst the non-DV offenders, and we had 12,247 of them, 14.4% received an imprisonment sentence. Amongst the DV offenders, 10,893, 16.9% received an imprisonment sentence, so slightly higher. And this difference was significant at the bivariate level, that is not adjusted for other covariates. Now the other question, of course, was the issue, was there an interaction between Indigenous status and DV status? And looking at that in terms of imprisonment, got a graph here, and basically on the vertical axis we've got the percentage imprisoned, and we're going to present them for non-Indigenous offenders and Indigenous offenders separately. And for non-Indigenous offenders, where it was non-DV, which is the lighter colour, 12% received an imprisonment sentence. Amongst the non-Indigenous DV offenders, 12.7% received an imprisonment sentence, so not much difference there. In terms of the Indigenous offenders, if it was a non-DV offence, it was 28.5%, so you can see that that's a lot higher. But now, for an Indigenous offender where it's a DV offence, it's even higher at 38%. And that, if you like, the fact that you don't have a difference between between DV and non-DV for the non-Indigenous, but you do for the Indigenous, that is technically an interaction effect, and that interaction was statistically significant. But of course, no other covariates have been adjusted for yet. So before we do that, let's look at the characteristics of the offenders by DV status. And what we found is that compared to the non-DV offenders, the DV offenders had more concurrent offences. They were also more likely to be Indigenous. They had more prior breaches of violence or non-violence orders in the past 5 years. They had more index finalisations in 2012-2014 of the 6-year period. They were older compared to the non-DV offenders. They had fewer prior court appearances during the previous 5 years. They also had fewer prior appearances for serious assault and fewer grievous bodily harm offences. Now, given that there's those differences between the DV and the non-DV offenders, it's important to conduct regression to see if the effect we found before remains. What we found, the imprisonment percentage was higher for males compared with females, for offenders aged 25 to 44 years compared with the other age groups, for grievous bodily harm assaults compared with actual bodily harm, where the defendant plead not guilty, they had a higher imprisonment rate. The more concurrent offences that a defendant had, the more likely they were to receive an imprisonment sentence. Likewise for the more prior appearances, and also more prior prison during the previous 5 years, more likely to go to prison. And also for prior suspended sentences. And also prior breach of violence, non-violence orders. So logistic regression was conducted to control for these covariates, and basically what was found is that DV by Indigenous status interaction graph I showed you before, that remained a significant effect. It was of the same magnitude. So at this point, what I could do is show you a logistic regression table of that regression and odds ratios, but odds ratios are harder to interpret, and also particularly where you have interaction terms. So an alternative is to actually, from the regression, show the predicted probabilities of receiving a prison sentence across different patterns of the covariates, including DV and Indigenous status. So I'm going to show you that for Indigenous, for non-Indigenous and Indigenous defendants respectively, but that will start with the base case, and that is the pattern of the covariates. And what the base case is males aged 25 to 34 who pleaded guilty to assault occasioning actual bodily harm. The matter was finalised in 2012 to 14. They had one concurrent offence, no prior court appearances, breaches or prison in the previous 5 years, and importantly, it's a non-domestic violence offence. So if we start now with the graphs showing the probability of imprisonment for serious assault amongst non-Indigenous offenders as a function of various characteristics, starting with the base case, which I just showed you, the probability of imprisonment was low at 6.2%. If we change one of the covariates from that to be 3 or more concurrent offences rather than 1, that increases the probability of imprisonment to just under 1/5. If we then added that it's 3 or more prior appearances, that increases the probability of imprisonment to almost 38%. Now, when we include that there had been a prior prison sentence in the previous 5 years, the probability of imprisonment increases to just over 2/3. Now, importantly, what is of interest here is in terms of these patterns of covariates, what does a domestic violence offence mean compared to a non-domestic violence offence for non-Indigenous offenders? And basically the probability of imprisonment stays the same at 67%. Now we do that again for Indigenous offenders, and the base case there is 8.3%. 3 or more concurrent offences increases to 1/4. 3 or more prior appearances increases to 45%. Having a prior prison sentence once in the prior 5 years increases it to 73.8%. And then changing it from non-domestic violence to domestic violence increases it, albeit slightly, to 78%. So that's about a 4 percentage point difference. Okay, moving on to the second question, looking at the length of imprisonment amongst those defendants who were sentenced to prison. For non-DV offenders, the mean length was 364 days, about a year. For domestic violence offenders, the mean length was 370 days. And there was no bivariate difference in the mean prison sentence length between DV and non-DV. There was also no interaction there with Indigenous status. So if we look at the non-Indigenous offenders, non-DV was 357 days, for DV it was 353 days. For Indigenous offenders, non-DV was 382 days, and DV was 399 days. Now again, we want to adjust for covariates, and we found that the mean prison sentence length was longer for males compared with females, offenders aged 25 to 44 years, Indigenous offenders, offenders who pleaded not guilty, defendants who had more concurrent offences. So the more concurrent offences they had, the longer their prison length was. If the index appearance was in 2012 to 14, the prison lengths were longer. If it was grievous bodily harm versus actual bodily harm, longer prison sentences. If there had been prior prison for serious assault, the prison sentence was longer. And likewise, if there was prior suspended sentence, the prison sentence was longer. Linear regression controlled for all these covariates, and still there was no difference between non-DV and DV offenders in terms of the mean length of their prison sentence term. So, to summarise the findings, offenders found guilty of serious non-domestic assault do not receive harsher penalties. Indigenous offenders found guilty of domestic serious assault are more likely to be sentenced to prison. And no difference in sentence length was found between non-domestic and domestic serious assault offenders. So, like all research, there are limitations to the study. The analyses, as I said before, are restricted to serious assault offenders only. Another issue is that the seriousness of assault may not have been captured sufficiently by the administrative data, that is actual bodily harm, grievous bodily harm. There might have been other matters brought before the court which indicated how serious the assault was, and perhaps some of the finding that the DV for the Indigenous offenders was more likely to get prison might have been captured by some of that seriousness data, but we didn't have that to include in the statistical analyses. The other issue is that bail status could not be included in these models, and one of the reasons is that we had the bail status at the finalisation. We didn't have it at the beginning of the matter, and of course during the course of a hearing and the time that takes, the bail status might change. And one of the concerns we had is that the bail status at finalisation may be endogenous to sentencing decisions. That is, bail may be refused where prison is the likely outcome. And finally, replication of these findings with other offence types is important. We know from other research that's been conducted by Ringland and Fitzgerald that other offence types where you have a lot of DV offences include common assault, breach AVO, malicious damage to property, and stalking. And it could be for something like a common assault where imprisonment is low, you might want to look at other outcomes, such as supervised, unsupervised sentences. Thank you.